Howdy, my name's Brian Foley. I'm a criminal defense lawyer here in Conroe, Texas. We're going to be talking about the closing arguments in the Kyle Rittenhouse case, and we're just going to jump right into it. So let me give you my general thoughts. This is going to be a critique of stylistic, choices that they made, and then a little bit of explanation of the law, why things kind of happened the way they did. I think that in general, these closing arguments went way too long. They were each 2 hours, and then I think there were 3 speakers. So the state always gets to go first and last. So they got to go first, took 2 hours. Then defense took 2 hours, and then the state took 2 hours. So I mean, I guess if the state's gonna take 2 hours each time, the defense, you might as well take it just so there's not some impression that they're just pounding it in and yours gets lost in the middle, because that's always the fear as a defense attorney. Your stuff's gonna get lost in the middle. But all these closings could have been done in 20 minutes, maybe 30. 45 minutes is about the time you start losing people's attention when you're doing some kind of persuasive speaking like this, and most of what you're going to say there is going to get lost. So, and the closing arguments went that way. They kind of just rambled on in the middle, jumped from place to place. There was no clear cohesive structure to it. Both sides had some PowerPoints that again did not paint a clear line of the story. There wasn't a clear story told from beginning to end. There wasn't great opening lines. The first part of your close and the last part of your close you want to have totally memorized, where you're just staring at the jury and interacting there. And both of these guys, didn't do a very good job of that. So let's see, what are my notes here? So the different crimes that were charged was first degree homicide or first degree murder, intentionally causing the death, then first degree recklessly causing the death instead of intentionally. And I did this in another video that explained a little bit of the difference there, but it's really not a whole lot of difference. So the reckless mental state is one where it's more like if you were to drive a car into a building and hurt people inside the building and you didn't know there was anybody in the building. Well, it's super crazy reckless to just drive a car into a building, even if you're not intending on hurting anybody. If you end up killing somebody, that's going to be first degree murder in Wisconsin. So in this case, the acts are all very clear. He had the firearm, it's an AR-15. He shot it 4 times into Mr. Rosenbaum, and then 4 times in a second interaction a little ways down the road after he felt like he had to, I guess, run away from that first scene. So I don't think that's reckless at all, but they talked about that. There also is going to be a deadly weapon paragraph finding that the jury has to think about. Nobody really talked about that other than to say, yeah, a gun's a deadly weapon. So let's talk about the beginning of the prosecution argument. So the prosecutor started, and the first words out of his mouth were, let me assure you the judge's statements are correct. Not Kyle Rittenhouse is a murderer, or Kyle Rittenhouse asked for what was coming, or, there could have been something. The first words out of his mouth there for closing argument were, I assure you the judge's statements are correct. And that whatever was in the jury charge was going to be available to them and then said how he knew it was confusing. He said, then this is the next thing he said. Can you tell I don't like this? This is a terrible beginning. I don't care which side. I'm going to be critiquing both sides here, but this is a terrible advocacy beginning. He said, there has been confusion and a lot of static with this case. Let me make it crystal clear for you. Well, if you just announce and declare to the jury that there's been static and confusion about the case, you're admitting that it's not a clear case. And as the prosecutor, you have to prove the case beyond a reasonable doubt. It's the highest burden in any legal system. It's got to be pretty clear. If it's not clear, it's a not guilty, right? I mean, this guy starts off saying, thanks, Judge. I think I agree with everything the judge said. So it's a great way to stroke your ego there. And then there's been a lot of confusion and static with the case. No, that's not. This opening for the prosecution should have been Kyle Rittenhouse came to Kenosha with the intent to kill, and he killed 2 people and shot another at point blank range. This is a clear-cut case, right? It's not, everybody knows it's not a clear-cut case. It's a close case, if that, based on the video and the way that the self-defense law works. But again, if you're the prosecutor and you're gonna prosecute this case, be more clear with what you want and why you think it. I mean, he's saying this stuff because he knows he has to make it clear for them. So instead of just saying it is clear, he pretends to, give homage to the fact that it's confusing to try to then rein them back in. That's not very good. Let's see. Wasn't there for the same reasons as the protester. Why was he there? Okay. So then they kind of blame Rittenhouse for not being there to support Black Lives Matter at the beginning. He was like, he wasn't there for the same reason as the protesters. Why was he there? And the prosecutor argued that, he was there to get into a fight, bring the gun to ramp things up and kill somebody. And then he said this, we shouldn't have 17-year-olds on our streets because this is what happened. Was Kyle Rittenhouse, was it because he was 17 and on the street that people got shot? That has nothing to do with anything. It was just a throwaway line. I'm not sure why it was even said. Then let's talk about his slides. So the prosecutor had these PowerPoint slides, which I think that PowerPoint slides are really good to convey imagery to the jury. Literally, you can show pictures, show video, quotes, I think that are good as well. But when you're writing your argument itself on the PowerPoint, you're missing the point of the PowerPoint. You're taking the power out of the point. You're not making your point. It's terrible. Don't do it. Worse, these slides that he had, stylistically, it was gray background, dark gray lettering, or the opposite, dark gray background and light gray lettering. One of the two. Both were awful. You could barely read it. I was looking at it HD on YouTube and I could barely read the things. And he just kind of wrote out what he was going to say. And, didn't really know what he wanted to say, I guess, and needed the slides to remind him. But then he had this slide and it had 3 bullet points. And the last 2 bullet points were, I'm going to talk about the irrelevant issues that defense is bringing up. Well, if they're irrelevant, then don't talk about them. Or I'm going to show you how Kyle Rittenhouse's actions weren't self-defense. Does that sound better than I'm going to talk about the irrelevant issues? I mean, that was just terrible. They said that Kyle had expected and anticipated violence that night, fraudulently claiming to be an EMT. And so prosecution really, one of the things prosecutors like to do is say, oh, well, the defendant lied about this. The defendant lied about X, Y, Z that were kind of tangential. That shows you the mental state. He was there to lie, to con, and get some free shots in. This is what they were trying to say. Then they talked about provocation. And so the defense, we'll get to that later, but the defense brought up that provocation was not mentioned in the opening statements, which is a really bad sign for the prosecution. That means if you don't have a cohesive theme from your opening statement to your closing statement, that means the facts changed on you during the trial and you had to adjust. And that's what defense said, and that's what this appears to be. Let's see. They used Exhibit 73, which is the full drone video. That was pretty cool. Again, that was a good use of visual. I liked it because it is what it is. It's showing you the evidence and it's reminding you of what happened. And then all you got to do is say a few words on top of it. And then people will basically think, yeah, that's what's happening in this video because I'm watching the video, but I'm hearing you. So that's a really good technique if you're doing a closing argument. Show them a picture, tell them what it means. That's great use of PowerPoint. He says you lose the right to self-defense if you provoke the interaction. That's true. You do lose your right to self-defense if you provoke the interaction, but that's more like if you show up to somebody else's house for a settling of grievances and you bring a gun. That might be provoking. But I think what's very interesting about this case and what the jurors are going to have to decide is, what did this environment do? How did this environment that they were all in change the way that the self-defense law applies? And I think that's the really interesting, novel question about this case. How do you view that scene out there? Do you view it as a peaceful protest interrupted by a madman 17-year-old with a firearm? If you do, then maybe you think that he provoked, Rosenbaum, who I guess is a sex offender, maybe a multi-time sex offender. And there's some videos of him later on in the night, or earlier on in the night, screaming for another person with an AR-15 to shoot him. He said he was screaming, "Shoot me, N-word, shoot me, N-word," to some other person earlier in the night. So very unstable person, it appeared to me anyway, at least however he was that night. But yeah, so if you think that it's a violent protest, or not a violent protest, but a violent, like a riot, then, you have a guy who's there trying to help people defend property, then you can't just chase him when he's got a gun, right? And this is another interesting thing. But again, that's going to be the split. If you view it one way, you might come down one side. And so that's why I think this is all going to come down to jury selection and the political biases of the individual jurors. You could even get a hung jury. But let's see. Here's another interesting thought here. So what this boiled down to me is this: I have this recurring thing I'm noticing. We get these cases with self-defense and murder cases where someone has a gun, and the person with the gun says, back up, get out of here, I have this gun, right? And then the other person who's not armed continues to advance towards the person with the gun. Is that deadly force? If I've presented deadly force to you with my gun, and then you are not deterred by that at all, are you now presenting deadly force to me? Because if you keep coming to me and take my gun, then you're probably going to take it and shoot me, right? I mean, I think that's a reasonable thing to think. But does that really measure up to imminent? Do I have to wait till you do take the gun, then I can get another gun? I think those are the close calls that in Texas, this wouldn't have made it past a grand jury, in my opinion. I think a grand jury in Texas would have looked at this and said, guy's coming at you and you tell him you got a firearm and he's still coming at you, you're done. So interesting, in Wisconsin, it's a little different. So, okay, moving on with the prosecution. The prosecutor pointed out there was no threat made to Kyle Rittenhouse by Rosenbaum, the first guy who got shot, at least nothing on video. There were some people who testified to that, and there's some video of him again, like saying for him to be shot by someone else, but no evidence of that according to the prosecutor. Then they made an argument because there's this thing called stippling on the victim's hands, Rosenbaum's hands. Stippling is like a black powdery substance that comes, it gets discharged onto your hand if your hand is near or really anything. It could be on your shirt, on a wall, whatever. You shoot a gun near some object, gunpowder is going to come out of the end of that gun, and it's going to get on the things in front of the gun. So this guy, Rosenbaum, the first one who was shot, he chased Rittenhouse. Rittenhouse was running away from him, and Rosenbaum chased him into between two cars, and then Rittenhouse shot him. Well, his guy's arm has stippling on it, indicating that the arm was near the barrel, maybe within 4 feet, according to the experts. So, what does the prosecutor say? Well, he was just kind of batting. It was just because he was like lunging, and then or maybe not lunging. You see, it's very difficult to argue this. It seems like he was going towards the rifle with his hand. Otherwise, you're not going to get the stippling on there. And so, prosecutor did this other thing. He said, let's just carve out Zemansky out of this case. So Zemansky is, before Rosenbaum got shot, there was one bullet that was fired. It was fired by a guy named Zemansky. And Zemansky was like behind, and he was seen with Rosenbaum earlier in the night. There was no indication that they knew each other, but they seemed to be hanging out quite a bit that night. Well, Zemansky and that initial shot, that's argued by the defense to say, like, well, Rittenhouse is getting chased by this guy. Rittenhouse hears this shot, this gunshot. He thinks maybe, Rosenbaum has a gun, or is at least, not deterred by Rittenhouse's gun and is continuing to chase him. And so the prosecutor says, let's just carve him out of this case. And anytime a lawyer is telling you, like, literally to cut something out of the case and don't consider it, that is a red flag. Okay. I don't think that's ever a good strategy if you're the lawyer trying to argue the case, because it's so easy for me as the other lawyer to be like, he's trying to make you throw away evidence. You can't throw away evidence. Whose story fits with all the evidence? Oh, it's my story that fits with all the evidence, right? I'm always, anytime I make an argument to a jury, my argument is going to be a cohesive argument that fits with all the evidence. And if he wants to say something cuts against me, I'm going to have an argument that it cuts for me. And you just got to be, you need to think about that. So like Zemansky, this whole thing, if you wanted to say like carve out Zemansky, the guy who did this first shot, is you say, the defense, is trying to pin everything on Zemansky, a guy who Rosenbaum didn't know, wasn't in front of Rittenhouse, and they're trying to tell you this thing happened so fast that Rittenhouse couldn't think, and yet he was concerned with a guy who was, off in the woods. Like, that's ridiculous, right? Just dismiss it by making an argument that dismisses it, not by asking the jurors, please just forget about it, right? That's not effective. And then I think this is the worst. This is the worst argument that the prosecutors made. So Kyle Rittenhouse shoots Rosenbaum 4 times, but in like less than a second, like 0.75 seconds, something like that. Bam, 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 bam. That might as well be one shot. I mean, I don't know about you guys, but like if you've made the decision, if I've made the decision that I'm going to shoot somebody because I think they're going to kill me, I'm probably emptying that clip. Like, I mean, maybe not 30 rounds in an AR-15, but like I'm shooting quite a bit. If I have like a pistol or something like that, I might empty the clip. Magazine, it's not a clip. I get it, guys. Clipper strips. I'm not one of those. But anyway, I might empty the magazine. Because if you think that you're justified in killing, you're justified in killing. The prosecutors tried to say he didn't have to shoot him all 4 times. That the first shot blew up the guy's hip. It's an AR-15, hits you in the hip, blows up the hip, right? He's totally immobilized after 1 shot. But shots 2 and 3 and 4 are bang, 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 bang. I mean, bang, 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 bang. And the prosecutors really argued with a straight face that he could have paused in a moment of reflection after the first shot. No. I don't think anybody was taking that credibly. If the jurors come back with a guilty on this, that may be. But it is not going to be because of this argument that you don't get a pass. This is what he said. You don't get a pass for firing the weapon fast. He's responsible for every bullet that comes out of that gun. He didn't have to shoot him 4 times. And the 4th one was in the back, right? Well, it's bam, 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 as the guy's falling. Well, the 4th one, the trajectory of it goes down the back, like from top to bottom. It's not through. It's not like he was on the ground and then executed him and went through and the bullet came out in the stomach or something like this. And this is what defense argued. Defense was frequently arguing in this case, the forensic physical evidence that proves exactly how things went. And the prosecutor kept arguing like the circumstances of how it went. And that is normally flip-flopped. Normally it's the prosecutors who have chosen to move forward on a case because that physical evidence doesn't change in it. It just says what it says. And so that is going to be a difficult thing for the prosecution to overcome here. But yeah, I think that was a garbage argument. He doesn't get a pass for firing the weapon fast. Another thing people have seen online is the trigger discipline of the prosecutor. So like when you have a firearm, the trigger goes in like this. If I'm holding where the trigger is, well, that's how you pull the trigger. You don't ever put that finger in there unless you're ready to shoot and kill somebody, right? Even if you were in court, that finger should be like this, on the edge of the and above and outside of the trigger guard. So if you're handling a gun in court, don't ever put your finger in the trigger guard. And then these attorneys in this trial, they kept handing the guns over to the bailiffs and the investigators and stuff to check to make sure that they were not, loaded or whatever. I mean, that's fine, but do it beforehand. Do it while the jury's not in the room, and then tell the jury like we had the bailiff check to make sure that this firearm is inoperable or whatever. Or just check it yourself. I mean, and I remember the prosecutor picked it up. He handed it to the bailiff or whatever, or the investigator, and was like, "Here, can you check this, please? Can you check it for me?" Like he didn't know how to check a firearm. I'm like, if you're not cool enough to check the firearm yourself, plus if you pick up a firearm and you don't check it yourself, like you shouldn't be handling a firearm. If you don't know how to check the firearm to make sure it's not loaded, don't touch the firearm. That would be better. Obviously, I don't think this prosecutor's shooting AR-15s every day. All right, so moving on to defense. So defense closing argument. Defense had a better opening, at least. It wasn't great, but he said, the truth matters and this is not a game, and the prosecutor lied to you about what's on video. I mean, that's a pretty powerful initial thing. That dude's a liar, that prosecutor's a liar, right? And then the truth matters and it's not a game. So his theme seemed to be, we're just gonna go over the facts and the evidence. Let's see. Yeah, and he also said, opened up with Mr. Rosenbaum was a bad man and my client had to deal with him alone. And he played up, again, defense played up the idea that on the street, it was, it was a little bit of chaos. And it's not just self-defense like you at your home, it's self-defense of what would you do when you're out on the street and the mob comes to get you. And that brings me back to the prosecutor. Two things I wanted to mention about what the prosecutor did. He called Rittenhouse an active shooter and tried to invoke like the Columbine, the Aurora movie theater, the one at Sandy Hook, things like this, like somebody actively out there trying to murder as many people as they could with an AR-15. People are familiar with that image. So he tried to say, well, because he was an active shooter, that means the crowd of people gets to mob him and take him out, right? Maybe not kill him, maybe kill him. And they did actually argue this, that they could have just, that one of the guy who got shot in the arm in the second interaction and did not die, that guy had a gun and was actually pointing it in the direction of Rittenhouse at the time that he was shot. And so the prosecutor argued that that guy could have just killed him. And later on, that guy posted on Facebook that his only regret was that he didn't shoot and kill and empty his magazine into Kyle Rittenhouse. So the prosecutors argued that the crowd was right. The crowd was in the right, and the crowd had heroes in it. And to me, the defense didn't really hit that very hard, but that would have been what I hit the hardest. Is I would have said, if the crowd is right, that means the mob can kill you, and none of you are safe, right? And put the juror in that situation. Like, if the crowd is right, and was this a crowd full of heroes? Was Rosenbaum a hero, 2-time sex offender? Was this guy a hero who was a felon who had a firearm and was chasing Kyle Rittenhouse? He shouldn't even have had that firearm, Was that a hero? Saving people from an active shooter? If Rittenhouse was an active shooter, he was the worst active shooter of all time. He only fired 8 rounds out of a 30-round magazine and only killed 2 people, both of which were chasing him at the time. I've never heard of an active shooter shooting only people that chase him, right? I mean, these are all the arguments I would have made as defense, because that was the only way that you can think that some of these arguments are valid for like the crowd being able to just chase down and do something to somebody. That's only if you think that he's an active shooter. And it seems like this is not an active shooting event. This is a political event, got out of hand. He brings a gun. People are not threatened by the gun, in fact, daring him to shoot him. And then where we are at now. And so that, again, how the jury deals with that context of what does it mean? How does the self-defense law change and manipulate in your mind when the context of what you're in is this riot or peaceful protest or whatever you're going to call it? Let's see. Okay, so another critique of defense, he kind of talks about what he wants to do, and he says, hopefully I'll bring it home in an honest and forthright fashion. That's a direct quote. Hopefully I'm going to bring it home, this argument, in an honest and forthright fashion. You don't want to be hopeful about that. You want to just do it. You're going to say, I'm going to tell you the facts in an honest and forthright fashion, unlike, guy over here who's lying, right? You don't say hopefully. So why did this guy, he's a very good attorney, right? All these guys are good attorneys, they're experienced, but Why did he do this? He was using the clicker. He was using the prompter button at this time. He was not paying attention to what he was saying, and he was just filling the words, filling the air with words. And that's what he was like. This is like his inner monologue. Like, I hope I do this right. And it's just because he's using the prompter. And he says, oh, you gotta love technology. He complains about the technology later on. Like, if you're in a presentation and your technology fails, don't say anything about the technology. Just go. Just keep talking. Abandon it. Finish whatever you're gonna say. Because if you don't already know what you're gonna say, you had no business getting up there in the first place. He goes on, he talks about how physical evidence does not lie. The prosecutor wants you to think Rosenbaum's hand is happenstance. Here's just a really ticky-tack critique I have. This defense attorney said havoc. Like, instead of these people were wreaking havoc, he would say the streets were like wreaked with havoc that day. And it's like, so if you are friends with somebody who says a word like totally weird like this, tell your friend to stop saying it weird like this, because it's very distracting for everybody. And if you can't stop saying it like that, don't say that word anymore. Pick another word. Wreaking hell, raising hell, going crazy, whatever, causing a crime spree, or just keep calling it riot. Don't keep saying the word havoc like that. I don't like it. And if it's your co-counsel that's doing it, tell them. Don't just be like, well, that's just how he says it. If everybody else in the world thinks it's weird, don't let them just keep doing it because that's what they like. It's fine if you want to do that in your personal life, but we're trying to persuade a jury here. We're not going to take shortcuts like that. We're going to do it the way that's the most appealing to all of the jurors. So let's talk about his other bad things about defense argument. Defense argument got lost. Flat out got lost in the middle. His PowerPoint presentation had like a picture of every witness, and his organizational strategy was, I'm going to show a picture of each witness, and then I'm going to talk to the jurors and remind them about what each witness said that I liked and didn't like. And I have my little notes or whatever from each witness about points that I wanted to make sure the jury knows all the points that I thought were good about each witness. And I guess we're going to throw all the arguments out there and we'll just see what sticks, right? That's terrible strategy on that. He should have presented it as a story and laid out the events of what happened, sprinkling in those witnesses and quotes from them that were in the trial to provide the persuasive context that each part of the story needed, okay? Instead, he just showed the picture of the witness and then went over all the stuff that was important about that witness and then clicked to the next one. So then when he was on a roll and he stopped using the PowerPoint for a little bit and he made a little headway, then he clicks the next button on the PowerPoint and it's a witness he just forgot to talk about, which is a DNA analyst. And the point he wanted to make with this DNA analyst was that there was no DNA found on the butt or the tip of the rifle of like any of these victims or whatever. And the prosecution is arguing like, well, okay, that means they never touched the gun. And defense is saying, well, there was never a swab taken from the end of the gun. Like, do you see how far down the rabbit hole we are here? There's a video of people lunging at this gun. Whether they grabbed it or not, does that matter? Like, somebody's coming for this gun. The point of that was proven in the videos. Do we need to spend any time with that DNA expert and like how the DNA functioned in your closing argument for defense? Did that add anything to the context of what happened that night as to why these acts were justified? We know he pulled the trigger. Like the whole case you're trying to prove to this jury is, why were his actions justified based on what happened? What did these other people do? What did these other witnesses say happened? That was your argument. And then when you're talking about the DNA analyst and trying to remind the jurors like, hey, don't find him guilty just because of that. There wasn't DNA on the butt of the rifle. Like, you had your chance to make that point when the witness was there. They'll remember it, right? Or if you wasted your time there, maybe they won't remember that either. But that's not going to be the thing that makes or breaks his closing argument. Then he gets frustrated with the technology again because he was trying to skip through it too fast. He needed to sprinkle in their testimony with quotes about what threats they heard and things like that. Then there was some guy named James Armstrong who spent 20 hours editing a photo during the middle of the trial to try to show that something about like the way that Rittenhouse was holding the firearm at some point. This was, I think, an effort to show that it was provocation, that Rittenhouse pointed the firearm at Rosenbaum before there was really a big interaction. And that therefore, if Rittenhouse points the firearm at Rosenbaum, then he doesn't get to shoot him because Rosenbaum would get to defend himself from maybe being shot when deadly force was not presented. This was confusing when both attorneys talked about it. I think that this is because this was not expected by either attorney. What defense tried to do is they said that it was hocus pocus and the image was out of focus, which I love the rhyme scheme there. I wrote it down, but I probably could have remembered that anyway. The hocus pocus photo that's out of focus. That labels it pretty well. You know, it's kind of like Donald Trumpy in the way that the way they talk about that, but I don't think that was the big deal. I don't think this case is going to get decided on that point alone. I think it's going to get decided on how do people view the context of that event. Okay, they finished with Dr. Kelly, who talked about the stippling on his hands. The defense talked about that and showed that that means he'd have to be lunging at him. But again, defense seemed to be methodical. Like, I'll bet he's a former prosecutor. He just presented it one after the other. And there was, again, my main critique of him is there wasn't a cohesive story that he told. He just kind of went over all of his arguments and then attacked the prosecutor. And if you just keep hitting the prosecutor over the head like that, as him being a jerk, you know, well, the jury's either going to think he's a jerk or not already. So you're not gaining many more points. You can call him a jerk once and a liar, point out the lie, but, you know, you could see he was a little frustrated with the process and everything. But I think if he was really that frustrated, he could have gone even further. So I would have gone, he was very in the middle, and I didn't like that. Either just play it straight and just say, yeah, these are lies, and I'm not sure why they're so concerned about this. The prosecution's doing this deal. Or go totally, you know, off the wall, be like, this is the most ridiculous miscarriage of justice in the history of the world. You know, these prosecutors ought to be strung up outside the courthouse for this behavior. Like, are you here with me? Like, jurors, are you seeing this? This is what we've been fighting against. This is the kind of ridiculous behavior that lands innocent people in jail, and it could come for any one of us if it can happen to Kyle, right? I mean, you could make that argument if you really think the district attorney's office is fudging, you know, hocus pocus and it's out of focus. If you're saying basically they're doctoring photos to try to convict your client, that's extremely serious, and maybe you need to amp the emotion up a little bit. But he was very in the middle. And it wasn't terrible, but I think there was obviously room for improvement. Best thing the defense did was show the chaos of the night. The defense, and finally their PowerPoint, their slides worked when they actually showed photos and videos from what happened that day. And they showed a lot of people holding AR-15s. It wasn't just Kyle Rittenhouse there that night who had an AR-15. Like, it had all these protesters surrounding and confronting these people with the AR-15s. And then it showed Rosenbaum step up to one of them and say, shoot me. And like, obviously he's very angry. You can see his face is angry. The defense points that out, but they're not just saying he was angry. They're showing you the photo. Look at that angry face. That's great use of PowerPoint. And so when they did this, that's when you could see, again, look at the chaos of this night. And they said that this crowd when Kyle was by himself with an AR-15, then they all went after him. That's what they said. But look at this interaction here when there was like 5 or 6 of them with AR-15s. Nobody was doing anything to them, right? And so, yeah, that was the main closing arguments of the prosecution and defense. There was a rebuttal argument by the prosecution. It was done by a different prosecutor, and he made some different points, but really, you know, he kept with the basic points that they made, but his theme and approach was a little different. And he actually said in that second close, like, forget about the provocation for a minute. You just don't get to shoot him this 4 times in a row that fast. And I just don't think the timing, telling somebody that they have to bang, bang, that fast, you have to consider whether or not his hip has now exploded and he's immobilized. After each bullet, you have to go one by one and do a reevaluation of his threat level to you. Yes, maybe after that first, because the prosecutor is essentially arguing this. When you are arguing, you have to think about each timing of the bullet. You're arguing, Well, yes, maybe that first shot was a good shot, but that second shot was not a good shot. So have the right to kill, boom. Don't have the right to kill, boom. Oh, murderer. Right? That would have been a good way to argue it as defense, I think, is point out, okay, justified shooting, murder, super murder, but it's all bang, 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 bang. If you're shooting, I don't care how many rounds you shoot, if it's less than a second, if it's less than 1 second, if the first round was justified, I'll bet the fourth one was. I just think that's not a great argument. And that was what they led with on the prosecution's second. But this video is already too long, and I hope everybody enjoyed it. Comment below what your thoughts are, and if you have any other critiques, include them, link to your video. Love to debate it. Oh, let me give you a prediction. I predict that they'll either find him not guilty of all counts, or they'll find him guilty of the first-degree intentional murder. If I had to bet one way or the other, I would say probably not guilty on all counts.